Special issues are typical in college litigation. I thought we would address a few. I've already mentioned the unusual role that affirmative duty plays in our business, rescue law. Special relationships and assuming duties really take prominence. Courts will say that there's no special relationship between a college student and their institution simply because they're a college student. Now, there could be special relationships arising from other relationships, for example, being an invitee, a business person, or a business relationship on campus. Assuming duties can create an equivalency, but the mere fact that we have a college-student relationship itself doesn't create a duty. Perhaps it's safe to say, strangely enough, that the college-student relationship is not special, but sometimes college students do have special relationships with institutions. There's a mouthful. There are also things beyond negligence law. So, for example, there are many federal rules and regulations that impact safety, predominantly the Clery Act, Title IX VAWA SAVE, and the Safe and Drug-Free Schools and Communities Act. I did want to draw your attention to the National Center for Public Safety, which has emerged at the University of Vermont. This is really a first for the federal government to have this type of center, and it shows the importance that the federal government is placing on public safety on campus. And I think this is a critical thing that we need to keep in mind, that in many ways, higher education institutions are now being asked to operate to hospitality industry standards with respect to our students and the various operations that we have. That implicitly, a lot of courts seem to be recognizing that. And so we're beginning to get some kind of equivalency to similar industries, although again, the hospitality industry is not identical to ours, and we certainly have some major differences. I mentioned sovereign immunity. I thought we might just cap that very quickly. One thing to think about when suing the government is there are often special procedural requirements with very quick timelines. Failure to comply kills your case. Caps on damages, limits on types of damages, and what becomes particularly interesting in a lot of sovereign immunity litigation is the interplay between potential institutional responsibility and the liability of officials. This is often where you'll hear the term Section 1983 come into play. This is a federal statute which prohibits deprivation of civil rights by a state officer operating under color of state law. So we will see sometimes individuals hailed into federal court under Section 1983. But frankly, it's pretty complicated, and there's a lot of lawyering that goes into this. You'd be wise if you're at a public institution to spend some time with your counsel making sure you understand the parameters. It also tends to be very state-specific in a lot of issues, so it's hard to give general guidance. The Clery Act. How did the Clery Act come into being? Through a terrible incident. The family went to Congress and said, we want some change. And the clear change that they wanted was better campus crime reporting, which gave us a focus on the so-called ASR, the Annual Security Report. And that still remains the core of the Clery Act, campus crime reporting. It also put a lot of emphasis on people we call CSAs, campus security authorities. These are individuals who become essentially connected to the campus crime reporting process. They also have taken on responsibilities associated with new Clery Act mandates, newer, the so-called timely and emergency notification requirements. And for today's purposes, I think it's just important that you remember that Clery has two distinct mandates that relate to each other, timely and emergency warnings and notifications. And there are standards for each. There's some overlap, but they are distinct. This is really a topic for more advanced learning, but I wanted to make sure that you understood. When we talk Clery, we're talking about ASRs, compiling annual reports and publishing them, with CSAs, who are campus security authorities, and we're thinking about timely and emergency notifications when appropriate. And then most recently, we've seen the so-called VAWA SAVE amendments, which are Title IX-like amendments that have been appended to the Clery Act. What we're seeing with the Clery Act is it's slowly evolving from a reporting act to a safety act. But it's still in the progress of doing that, and there's quite a bit down the road before it truly becomes an omnibus college safety act. Safe and Drug-Free Schools and Communities Act, the sleeper, Edgar 86. These regulations could use an update. It's been a while since the department has updated these regs, and they've got some charmingly retro features to them if you work with this. One of the features of the regulations implementing the Safe and Drug-Free School Act has been the need to do a so-called biennial report. And frankly, until relatively recently, there wasn't much enforcement of this. So we didn't really see significant higher ed enforcement of safe and drug-free schools. That's been changing a little bit. I'm sure I have someone out there right now who's experienced a Title IV audit where local folks from the Department of Education or Central Command itself has been asking for more information about your compliance with Safe and Drug-Free School. What does Safe and Drug-Free School focus on? Alcohol and drug prevention. And increasingly, I see people discussing the relationship between alcohol and drug issues and violence and core mission delivery. Safe and Drug-Free Schools puts a lot of emphasis on the use of science and public health modeling. Hazing. I pull hazing out because it has been in many ways one of the most vexatious safety issues that's out there, and it has a certain unique role in American law. I assume you know, you might not, that there's no specific federal law as such which prohibits hazing. It's a state law matter. There are federal laws which could implicate behavior that's otherwise considered hazing, but there's not a specific hazing federal law, which is kind of interesting, and one wonders if someday Clery might have such a mandate in it. It's mostly speculation. We certainly know that this is not just a fraternity issue. Robert Champion's incident illustrates the fact that hazing can occur in other types of activities on campus: bands, clubs, sororities, even in the classroom. Anti-hazing laws throughout the state vary. One thing that's intriguing is it's virtually ubiquitous that the role of consent and assumption of risk is abolished in the statutes, or to put it another way, you can't raise the defense of consent or assumption of risk to hazing in most states. Reproduced a couple of representative hazing laws from around the country, Massachusetts and Florida. The Florida law is often thought to be one of the strictest. It's gone through several iterations. There are still places that permit the defense of consent or assumption of risk. Florida certainly isn't one, and the vast majority of states do not. The really challenging feature of hazing is trying to figure out who's responsible and whether it should be civil, criminal, or even regulatory responsibility. It's been particularly difficult to combat hazing, and I'm a big fan of Eric Hoover's piece on this for the Chronicle. It's one of my favorite pieces he's ever written. It's very personal, actually, coming from 2012. And Eric ponders, are students hardwired for hazing, and have we really ever come up with effective techniques for combating hazing? I will say that it has been one of the most difficult and intransigent issues in higher education safety, and we're hoping that perhaps breakthroughs in brain science will someday lead us to a magic bullet. What is amazing about hazing is that it's so interrelated with other negative phenomenon. I personally think all hazing is a form of bullying, although not all bullying is a form of hazing. It's a subject of debate. I'll let you debate that. Hostile environment under Title IX is very similar, and hate speech has some overlaps as well. My best advice on campus is that when you're dealing with any one of these, hazing, bullying, hostile environment, or hate speech, you really should consider the impact of all of them on each other. Don't try to take one of these at a time. They're actually very interrelated phenomenon with interrelated compliance metrics. The federal government gave us some fairly complex guidance on this, and it's worth, if you want to get to a more advanced level, to pull that guidance and see the interconnections even the federal government sees. There are challenges in attempting to combat hazing by going straight at fraternities and sororities, and there have been a lot of issues about associational and expressive right freedoms and even relationship agreements with fraternities and sororities. So this will push over into the equity component of our pathways. It'll also impact the free speech pathway as well. Title IX. Today, Title IX is on everyone's lips. It's perhaps the thing that's most talked about in higher education. If history serves as a reminder, there could conceivably come a time when Title IX is not the top agenda item of the day, but it certainly is today. What is the mission of Title IX? It's actually pretty simple. Reduce or eliminate barriers to education opportunity caused by sex discrimination. I think when in doubt with what to do with Title IX, it never hurts to return to the spirit and the mission of Title IX, and there it is. Originally very focused on sports issues and employment, harassment and hostile environment, but today we've gotten a lot more emphasis on sexual violence and even on retaliation. Keep in mind that Title IX's mandates are very organized around institutional response. We have response obligations. Why? Because we're not usually the people doing the bad things. We're often responding to things that have been done that are wrong. Of course, we're not encouraging our employees to commit harassment. And when students do it, we're not encouraging that either. So who are we? We're responders. We have significant investigatory responsibilities. And again, highlighting some of the critical features of Title IX, our response triggers upon actual or constructive knowledge, which is reasonably should know. This differs from the old era under previous Supreme Court cases where actual knowledge was the trigger. Now, actual knowledge plus constructive knowledge can trigger an obligation. We have to be prepared to make prompt, thorough, and impartial investigations, and we have to be particularly susceptible and aware of the fact, take that from the top, we have to be particularly aware of the issues that arise when sexual harassment rises to the level of hostile environment, but we also have to deal with sexual harassment that is not rising to the level of hostile environment. I've tried to organize the guidance from the federal government under Title IX into 4 distinct areas. We have specific modules that deal with this in more depth, but I'd like you to at least be exposed to the 4 corners approach if you haven't had a chance to see those modules. All of the guidance organizes into either guidance about organization and management of our systems, investigation or discipline, assistance, and I use the term victim assistance because this is where the government started. Today, this is probably more appropriately denominated victim or impacted individual assistance. And then the final quadrant or corner is campus culture and climate. Corner 1, we're being told among all of the mandates, we have to have a properly trained and tasked Title IX staff, including a dedicated Title IX coordinator for large campuses. OCR's preference is a full-time Title IX coordinator. Not everyone can do that, but someone needs to be dedicated to the task. We need proper reporting structures and employment protections for operatives of the Title IX system, self-evaluation and study techniques to improve outcomes, and we need to have excellent Title IX management systems in place to provide good Title IX services. This means, among other things, good website design and management, faculty, staff, and student training and evidence of due diligence of that, and we have to be sensitive to learning environments where people live and learn, because any impact on program or activity conceivably raises Title IX issues. That includes externships, internships, and study abroad. Many of us have spent a lot of time emphasizing investigation and discipline under Title IX. We're required to have good data gathering, excellent mechanisms for reporting, responsible employees, for example, proper rules and procedures for discipline and grievance procedures. And grievance is a term of art that the Department of Ed uses. They assume they know that we know what they're saying. It isn't always clear to me that institutions fully understand the meaning of what a grievance system is, and that's actually been the source of a lot of controversy in some of the resolution processes. Special techniques are required for investigating sexual misconduct, particular emphasis on trauma-informed training, but that's not the only one. Appeal and review. We're not required to have appeal, but we are required to have review. And of course, all appeals are a form of review, but not all reviews are appeals. Most of us have appeals, but the question is, how do we structure a system that's properly reviewed? We need to create appropriate interfaces between Title IX systems, investigation, discipline, and grievance. And then we operate on a shot clock, the so-called 60-day rule. And although the government will allow us to relax the 60-day rule, we need to have explanations ahead of time, not excuses after the fact. Victim and impacted individual assistance. We need to protect, empower, and support victims of sexual violence. We have to be able to show we care and show and demonstrate that care. We need to be very compassionate and particularly sensitive to not re-traumatizing people or allowing them to be double victimized. Hence, an incredible emphasis in federal guidance on trauma-informed training. Security and safety are paramount. We have to make sure that victims and others are safe during the process, and this includes retaliation against respondents. Counseling services need to be made available. Perhaps you don't have them on campus, but we certainly need to have some access to appropriate counseling and medical services. Advocacy is becoming ever more important. We're familiar with the new VAWA Save potted plant rule. I suspect you've heard about that. People are now entitled to an advocate of their choice. Whether they participate or not is typically left to state law, and you may well work in a state already that's allowing lawyers as advocates to participate in some of the hearings. Academic support may be critical, and we're being asked by the government to put yourself in the place of a victim. What would you want? How would you like to be treated? Keeping in mind that you may not have had traumatic experiences of the type that they have, so you might have to work with them to determine what they really need as an individual. Corner 4, culture climate. Virtually every resolution agreement that's out there requires culture and climate checks or surveys. Even though it's not technically mandated under federal law at this point, it seems as if we've gotten a soft mandate from OCR to do this. So we're being called upon to do proactive work to check, address, and modify both culture and climate. Integrating educational resources directly into Title IX response systems has been a winning hand, and we've seen schools like Yale have success with this both operationally and also in their Title IX investigation process. Multiculturalism issues dominate. Many Title IX issues are actually sublimated, unaddressed multicultural issues. And we need to realize that the impact on differential populations is not insignificant. Any good Title IX system is supported by good multicultural work. By law, we must do prevention work. We also have been encouraged to do bystander intervention and training. A shout out to higher education and educational solutions. We invented bystander intervention, not lawyers or the government, but they're applauding our use of community efficacy-based training, sometimes under the moniker of bystander intervention. It's critical to integrate Title IX efforts with the greater enterprise risk management efforts on campus. Let's talk now about mental health and care teams. These have been around for quite some time, but there's no question that the development of care and intervention teams has really accelerated in recent times. Events like the Tyler Clementi incident and, of course, the tragedy at Virginia Tech certainly accelerated the use of mental health teams and care teams. There's also been an increase in demand for services. Most of the teams that I work with are fairly burdened with the amount of work that they have, both in terms of the number of people that they deal with, but also the increasing complexity of the issues that are presented. And then to top it off, there's just been increased visibility around mental health issues on campus. A number of legal cases have occurred, such as the Shin case at MIT, and many newspaper articles have begun to focus on the issues associated with mental health issues. One thing I think that's critical is that suicide often dominates the dialogue, although suicidality is actually not the thing that is the most frequent thing to be showing up in front of the teams. When it does, obviously, it is something of major concern, but there's a lot more that we deal with than just suicidality. I also think the need for teams has been driven by the fact that to some extent, traditional classroom faculty, I sometimes shorthand that as TCFs in my head, traditional classroom faculty, are sometimes a little challenged to manage millennial populations in the classroom. And those challenges often turn into requests to care or threat assessment teams to assist or evaluate, when in fact what we may be dealing with is some need for pedagogical reform. Throughout Compliance 101, I keep addressing the same basic issue, is that student affairs professionals are critical in curriculum delivery and development. We have our own curriculum that we are providing independent of some of the classroom faculty, but we're also finding ourselves increasingly involved in classroom design and delivery. The next frontier of Compliance University is clearly headed towards instructional design and delivery, and we have to be aware of the fact that faculty were not generally brought up in that world. They weren't pushed to focus on compliance metrics per se. Service, scholarship, and teaching dominated the hiring and promotion process. And so I think we're going to find ourselves increasingly over the next 10 to 15 years dealing with the need to interact more regularly with traditional classroom faculty. And the leading edge of this, I think, has been visible on care and threat assessment teams. Information silos also became an obvious safety issue on campus, particularly after the Virginia Tech reports. And one thing that teams can do is help to break silos down to improve casual and regular communication regarding safety issues on campus. And if your team is functioning really well, you start becoming the canary in the mine. If anything is not working on campus, really anything, the team begins to see that. And so I often tell teams that they've begun to mutate into sort of permanently in-camp self-study teams, whether institutions recognize that or not. These are indispensable units in enterprise risk management, and of course, obviously, in the core services that they deliver. There are some state mandates out there which I've addressed, but so far most states don't mandate teams. Virginia, for example, is one of the rare ones that does. We do think that in time, legal mandates around teams will probably grow. And it seems sort of inevitable now, particularly since there's been some identification of at least promising practices around team behavior. And we may be getting close to a period where we could actually begin to claim best practices for some teams. I mentioned this earlier, but I'll hit it again. It's not as if teams popped out of the air in 2007 after Virginia Tech. As Delworth has pointed out, we've actually had teams around for many, many years. My friend Gene Dysinger as well has written about this, and many campuses were doing this for a long time before it became more visible to the public. But I do think what's notable in recent times, particularly since the Obama administration in 2007, is acceleration of the use of teams. Campuses that have them have been augmenting them, and campuses that didn't have much in that way have certainly begun to develop these types of behavioral intervention processes. The Clery report process asks about our team. It sort of assumes we have them. And although there is not a specific Clery mandate to have teams, it's a little awkward when someone asks you, how's your team, and you don't really have an answer. So it's a bit of a nudge, wink, wink from the government that it may be time to consider having a team if you don't already. But again, I would imagine most of you already do. We think a Clery mandate will come. I've mentioned this several times. It's looming. Quick note on insurance. And again, this is no place to delve into the law of insurance or the policies behind insurance, but there's a couple things I think that we should be aware of at the most foundational levels. As you advance through your learning in Compliance U, I think you'll find that insurance issues actually become more prominent and specific, and we'll be returning to those as needed. But for now, let's focus on just one of the most basic set of questions I think that you might have. Should you have insurance? And there's some debate about this in the field. A lot of senior administrators now do carry insurance. There is a way to get it. There are resources for that sort of thing. It's not ubiquitous. It tends to be something the seniors or the most vulnerable operatives have on campus. Some folks focus on indemnification relations with their institutions. There are a couple schools of thought on this. One of the classic thinking is that if you don't have insurance, it makes you less of a target for an individual in litigation. I'm not entirely sure that's true or false. I think this is a question for discussion, and I could see where ACPA could have valuable open fora on this to continue to discuss the issue of whether insurance is a good idea, and if you have it, how you should operate it. You probably wonder who defends you. And, in some ways, this may be one of the reasons people will begin to move towards having insurance, not so much for the indemnification, but for the defense. Because keep in mind that if your institution is sued, the institution's lawyer represents the institution, not necessarily you. Your interests may be coterminous, but they might not be. And we've certainly seen examples in the media where student affairs administrators have found themselves in a conflict with their own institution during a litigation process, in which case, if you expect to have representation that faithfully represents you, you'll have to find a way to pay for that. Insurance will sometimes be a way to go about and do that. So I'm beginning to wonder if the two things that come in an insurance policy, indemnification and a defense, if paying for lawyers, the defense side, is actually starting to predominate in people's thinking. Again, this is something you could talk through on your own campus. I should point out that criminal investigations and the cost associated with those are typically not covered by insurance. And this is one place that a lot of student affairs administrators have been a little surprised from time to time. If you get caught in an imbroglio involving criminal issues, the time and money associated with that can be actually quite extraordinary. And most folks haven't really pre-planned or prepared for that eventuality. I think this is a discussion that you need to have. Although we right now live in a compliance university world, one dimension of compliance is criminal law compliance. And increasingly, the criminal justice system is watching what we're doing. Many campuses, for many years, the attitude of local prosecutors has been, you do your thing, we'll do ours. But that's changing in some areas, and we may see an uptick in certain specific times and places with more criminal investigation type work. The time is now to have these discussions because, again, who's going to pay for this? And often institutions themselves have to foot fairly substantial bills if a criminal investigation is taking place. Does insurance cover compliance costs? And that's a really interesting question, and the answer is really an extremely complicated yes and no. It would take probably the better part of a day to parse out all of the angles on this, but it's probably worth remembering that the cost of compliance is rising, and institutions and individuals are sharing that cost with insurance companies. Everyone is stressed by the time, energy, and money that's being spent in Compliance University. It's predictable that insurance companies will begin to look at ways to reduce their risk of large amounts of liability or payouts or compensation costs. And in addition, I think institutions are going to have to do the same thing. We're all looking for efficiency in this area. And so the real question is not who's going to cover it, but how do we manage these costs? If we are oblivious to the cost of compliance, it's something that's going to catch up with us in due course, probably sooner rather than later, forcing potentially fairly substantial changes in operational behavior. We're seeing an insurance reform process in front of us right now, and you've been exposed to this with ERM. The new thinking in the insurance industry, really not so new, but new to us, is the need to do preventative and preventative work to try to reduce the cost of compliance and the risk of liability. It's important for us to get in front of the issues of compliance as opposed to perpetually respond therapeutically to places where we've been out of compliance. Title IX is a particularly good example of this. We're seeing some campuses spend extraordinary sums of money, and I truly mean extraordinary, for events that potentially could be prevented with good upfront public health modeling and other preventative and risk management techniques. And hence the industry is pushing very hard, and the insurance industry is pushing hard for higher education to get into that preventative, proactive mode to try to reduce risk before it occurs.